Good day, Crime Talk aficionados. We have another great show for you today. First, new filings in the Bryan Kohberger case. Why so secretive? Lori Vallow gets a jury with 13 men and 3 women. Is her evil plan coming together? Karen Reed is also getting a jury selected, and her supporters are suing the judge. Fighting over DNA technology in the Gilgo Beach murders, a cold-blooded killing at a track meet of all places. A man who doesn't like large corporate pharmacies took matters in his own hands and killed an employee of one of them. Past performance is indicative of future results, ladies and gentlemen. I'll give you an example. We have This Day in Legal History and our Dumb Criminal of the Day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications of when we go live or put up new content. And you can check us out on any of your favorite podcasting apps as well. All right, before we get to the docket, a couple of reminders. First, yes, I'm still not in a suit today. No trial, no court. Coming off the big win, you got to just take a couple of days, kind of decompress. I get tired after trial, so yes, we came in casual, and it's going to be a snowstorm, a spring snowstorm today and tomorrow as well. Anyway, I'll be back in court tomorrow, so we'll have a suit on tomorrow when we meet. All right? And next thing, go to CrimeTalkSearch.com, sign up for that background subscription service today. When you do, you're going to be able to do a background search on anyone here in the United States. You're going to get a report emailed to you literally just minutes after you submit all that information. And the beautiful thing is you can get an update if any of that information changes. That report is going to have information as to phone numbers, emails, social media presence, whether somebody's married, divorced, do they have property, do they have judgments against them, do they have a criminal history, are they on one of those registries where you have to put your name on a list. All things you want to know, ladies and gentlemen. So go to CrimeTalkSearch.com, sign up for that background subscription service today, and hey, you can cancel at any time. So whether you want to do one search, 1,000 searches, 2,000, it's completely up to you. It's all the same price. All right, let's go ahead and open the record for April 3rd, 2025. And first on the docket, new filings have been released in the Bryan Kohberger matter. Only really one of substance because everything else is a motion to seal or an order to seal, and we'll go through that in a minute. There's one that's a little interesting. All right. This is why I think it's of substance to talk about. And it's captioned, amended notice of filing of declaration in support of defendant's objection to the state's motion in limine, specifically regarding text messages and testimony. As you may recall, the defense said, hey, these text messages that were sent on the night of the murders between DM and BF, right, the surviving roommates, they shouldn't come in, at least under the government's proposed theory. And as you may recall, we went through the state's reply as it relates to the text message testimony. And they said that the text messages include additional records from DM and BF's phone for the court's review. However, using the records provided in the defendant's response does not change the rules of evidence 801 and 803 analysis. The following phone records are from the November 13th, 2022 conversations between 2:10 a.m. and 4:37 a.m., starting at 4:19 a.m. DM makes statements to BF regarding seeing an unknown male in the residence. These statements are immediately after she perceived this event. In addition, DM and BF are under the stress of excitement caused by this startling condition. Basically, it's an excited utterance. You didn't have time to reflect and pause and do everything that would make it hearsay, so to speak. There's such amount of reliability because you didn't have time to think about it, just like spontaneous, like you're seeing, standing on a street corner and a green car blows through the intersection, hitting another car that's coming through the intersection. You're like, oh my God, the green car ran the red light. You didn't have time to reflect. The theory is that provides some sort of reliability. So the prosecution listed all the records that the defendant had and said, let's go through all these statements, and figure out why they're not hearsay. For example, at 2:10 a.m., DM to EG, the Uber driver, inquiring if he was the driving. Their prosecution's theory is not hearsay, not for the truth of the matter asserted. You know how I kind of feel about that. Well, if it's not being out for the truth of the matter asserted, then Why is it relevant? Of course, it's being offered for the truth of the matter asserted. So you better come up with something else. Clearly not an excited utterance at that point. 213, EGDM, confirming he was the driving. Not hearsay, not for the truth of the matter asserted. 351, DM creates a new contact in her phone. Not hearsay, not a statement. 419 and 07, BF calls DM. The record of the call itself is not hearsay since it's not a statement. In addition, BF and DM should be able to testify regarding what was discussed. Okay, so that just gives you an example of all of those things that originally the defense said should not come in. Prosecution says, no, they should come in. Not hearsay or excited utterance, not a statement, something along those lines, right? It has to be an exception to the hearsay rule. So the defense then filed a motion, and it's dated March 31st, but they just released it today or late last night. And it's, like I said, it's their amended motion regarding a text message testimony. It says, come now, Bryan Kohberger. Bryan, through his attorney of record, and hereby files the accompanying declaration of Josiah Roloff in support of their objection to the state's motion to eliminate regarding text message testimonies filed on March 17th. Now it goes through Mr. Roloff's qualifications to basically qualify him as an expert. And I won't go through each and every one of them, but he's over the 18 years of age. He's currently the president and senior digital forensic examiner at Roloff Digital Forensics, LLC, based in Spokane, Washington. That he provides digital forensic services and consulting in legal matters involving electronic evidence, including evidence derived from computers, mobile phones, memory cards, and other electronic devices, and databases from third-party electronic service providers. His background, his formal training, includes a professional certificate in computer forensics from Oregon State University and New Technologies, Inc., NTI, the Certified Computer Examiner, credential from the International Society of Forensic Computer Examiners, the In-Case Certified Examiner certificate from Guidance Software, and multiple certificates from Cellebrite, which is a cell phone, including the Cellebrite Certified Logical Operator, Cellebrite Certified Physical Analyst, and Cellebrite Certified Mobile Examiner. He also holds an associate degree of Applied Science and Network Engineering from Spokane Community College and a bachelor's degree in Liberal Studies with an emphasis in Programming Management from Whitworth University. Okay, so that's his training experience. Clearly has some specialized training knowledge to qualify him as an expert. He's worked in this area since 2003, and he's examined thousands of digital items, including hard drives, CDs, DVDs, floppy diskettes, thumb drives, flash drives, magnetic tapes, tablets, devices, cellular phones, SIM cards, PDA, smartphones, feature phones, and data obtained from internet service providers, cloud storage providers, and cellular service providers. He's worked on over 1,500 cases. Good to go. He's worked as a physical examiner, talks about some of his tools that he's done, training that he's done, and some publications. His clients include the United States Navy, Marine Corps, Army, Air Force, and Coast Guard, numerous federal and state public defenders' offices, the private attorneys throughout the United States, Europe, and Asia, and he's examined evidence in cases involving allegations of homicide, sexual exploitation, solicitation, sexual assault, unauthorized systems, etc. So he's got training and experience, okay? But then we get down here. Once again, he's familiar with everything. He's been retained by Ms. Ann Taylor in the defense of the case of People of the State of Idaho versus Bryan Kohberger. And he says, I've reviewed the documents titled DM 11.13 bubble format and BM 11.13 bubble format, which contain data extracted from mobile devices used by individuals identified as DM and BM, respectively. These document reflects periods of activity on the mobile devices that would require user interaction with the device for them to occur, specifically for the date of November 13th of 2022. Next paragraph. This document includes artifacts and contents demonstrating a variety of user interactions, including incoming and outgoing native text messages, incoming and outgoing Snapchat message artifacts indicated by the application identifier com.toyopag group.peekaboo, voice and video calls conducted via Snapchat and the narrative phone dialer, creation, modification, and deletion of multimedia files such as images and videos, application usage logs showing when specific apps were opened and closed, and internet browsing artifacts and cookies data showing access to particular websites or internet-based services. And he declares under the pain and penalty of perjury that the true before information is true and correct to the best of his knowledge and belief. And then, of course, he signs it ENCE, CCE, CCLO, CCPA, CCME. Really, we already got your certifications. Anyway, but what's the interesting point about that, right? I think what the defense is trying to show is that, hey, they did have time to sit, pause, and reflect. And although you want to get these in, look at all these other things that these people were allegedly doing on their phones during the time of these murders or shortly thereafter. And so they've had this time to pause, reflect, etc. It's not really, I don't really see what they're trying to do. If I was the defense attorney in this particular case, I would lie in wait and make these objections at trial, make the prosecution fight to get all this in. Now you're trying to get some sort of pretrial ruling, which the judge would probably say, I'll just make a determination when the evidence is presented. And if the appropriate foundation and authentication takes place, then it'll come in. If not, it won't. And it's got to be relevant and not prejudicial under 403, right? But they're basically trying to say, from what I can tell here, is these aren't excited utterances because they've had time to reflect and pause, because they're doing all these other things, taking other text messages, working on Snapchat, voice and video calls, creation, modifying, deleting multimedia files such as images and videos. So that's saying you've had time to pause, reflect, not excited utterance, hearsay, but it doesn't matter. These roommates are going to come testify. They can testify as to what they did. And then you're going to cross-examine the roommates. Well, isn't it true you're also doing this? And you didn't hear anything and you weren't alarmed and blah, 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 right? All the things that the defense is going to ask them. Yes. And then the prosecution then gets to get up and say, well, let's talk about this. Did you do this? Would it refresh your recollection to see some records during that time? Why, yes, it would. Why don't you explain what you were exactly doing? And so you're going to get all the same information. So I get it. It's a death penalty case. They're litigating everything under the sun to try and create some appellate issues if there is, in fact, a conviction. But it seems like a lot of work for not a whole lot of juice, so to speak. What do they say? The juice is not worth the squeeze, so to speak. Anyway, we had another order sealing defendant's exhibit in support of the affidavit and objection. So we've got that. A stipulated motion to seal exhibits C to defendant's third supplemental response to discovery. Nothing there. Defendant's third supplemental discovery response. But of course, they're sealed. Notice of filing of declaration in support of the objection. We just did that one. Sorry. The court order sealing exhibits to defendant's third supplement. We got that. Order defendant's objection to the state's proposed jury questionnaire. The court having before it the motion to seal defendant's objection to the state's proposed jury's questionnaire and good cause appearing, now therefore hereby orders the defendant's red line objections to the state's proposed jury questionnaire shall be filed under seal pursuant to Idaho Court Administrative Rules 32I and IC 74-124. I guess it's kind of work product, but we're talking about jury questionnaire stuff. This is not the first death penalty case in Idaho. You take the previous jury questionnaire. Yes, you kind of tailor it. Obviously change the names, but it's pretty straightforward. These are the charges. Is there anything about this? Tell us what your prior knowledge is about the case. Have you formed any opinions about the case? Is there any reason you can't be fair and impartial? Do you know the parties in this particular case? You have to death qualify the jury. So every juror has to be able to say, I will impose the death penalty if the burden has been met. And it's obviously kind of weird that you're talking about the penalty phase before you even get to the evidentiary phase, but that's the way you have to do it in a death penalty case. You don't get separate juries to hear those type of things. So they have to be death qualified. And then the motion to seal, once again, the exhibits, and the third supplemental response request for discovery regarding the death penalty phase. So the defense anticipates calling the following experts to testify at trial, assuming there's a conviction for the death penalty phase. A guy by the name of, or a female by the name of Rachel Lawson, PhD, Eileen Ryan, DO, James Aiken, Jeffrey Lewine, PhD, John Edens, PhD, Jolene S. Brams, PhD. And of course, the exhibits of their CVs and what they would testify to are not attached. But how many PhD? We've got PhDs, 1, 2, 3, 4 PhDs, one medical doctor, and an investigator. So this guy has been poked and prodded and shrinked up at least 3 times. 3 times, ladies and gentlemen. Sounds expensive. But that's what you have to do. It's a death penalty case. It's called due process, right? Everybody's entitled to it, so you got to do it. All right. We'll bring you the next latest on the Bryan Kohberger when it becomes available. We're getting close. We've got a motions hearings coming up soon, too, as well. So look forward to that. Next, let's talk about Lori Vallow. That's right. A jury has been selected in the murder conspiracy trial for Lori Vallow there in Arizona. And this is what I thought was interesting about this. There appears to be 13 men and 3 women on the jury. Obviously, 12 of those jurors will ultimately deliberate and 4 will be alternates. What are the odds that she has a predominantly all-male jury or near-male jury? Pretty high. And why is that significant? Because we brought you the story the other day. The courtroom observer said that she was being very flirtatious and vivacious when it came to the male jurors, and that it was their job to protect her, right? So yes, her evil plan is working, I guess. We'll have to wait and see. Anyway, do you think she's going to be able to put a spell on all of those jurors like she did with all 5 of her husbands? It'll be interesting to see who wants to be number 6. Who wants to be number 6? Wouldn't that be a tale to tell? How did you meet your wife, Lori Vallow? Well, I was on her jury and I quitted her and we met and now we have this long-term relationship. We'll never consummate the marriage, but at least we got rid of that deadbeat loser, Chad Daybell, right? Anyway, Lori Vallow is on trial in Arizona for conspiring to kill her former husband, Charles Vallow, who was killed back in July of 2019 by Lori's brother, Alex Cox. Now, Ms. Vallow has pled not guilty and said that she would be representing herself at trial. So far, she may be winning. Next, the Karen Reed case, also trying to get a jury. So jury selection in the retrial for Karen Reed entered its 3rd day, and they have now a total of 7 jurors selected so far from nearly the 200 prospective jurors that appeared for the last 2 days. Once again, selecting 4 men and 3 women. 5 jurors were picked Wednesday, and 2 were settled upon Tuesday. The judge has warned the jurors that they may be here for a lengthy commitment, estimating that the testimony in Reed's second murder trial could last anywhere between 6 and 8 weeks. Okay, this is a gift that keeps on giving to the Crime Talk channel. We'll take it. Unbelievable to me that it's going to take 6 to 8 weeks. This is at most a 7-day trial anywhere where I've ever practiced law. Crazy. Anyway, many of the jurors have indicated during the interview process that they've heard of the case already, they've formed an opinion, or have a bias to one side or the other, which obviously means why they're not there. Anyway, the judge expects to question another prospective 40 jurors today, but as of this time, they're not seated all yet. Anyway, like I said, the court needs to seat a jury of 12, including at least 4 alternates. Now, the first trial ended in a hung jury back in July of 2024, and as the jury selection unfolds in the courthouse there, supporters of Miss Reed are suing the judge over her decision to reinstate a 200-foot buffer zone outside. And their argument is that they are having their constitutional guarantees to protest being violated by the judge. They say that the buffer zone was put in place ahead of Reed's first trial back in April of 2024 due to the significant public attention the case had drawn and the extended last week by the judge at the request of the prosecution to limit demonstrators from gathering in the neighborhood around the courthouse. Now, the lawsuit seeks to block enforcement of the buffer zone, and the protesters want their rights restored. There's going to be a hearing before a federal judge on Friday, who I think is going to say a 200-foot buffer zone is sufficient to obviously meet the needs of the state, to protect the juror, to protect the integrity of the proceedings, and yet still allow these people to voice their opinion. Now, there was, words that could be heard from in the jury room from protesters in the first case, and that can be intimidating. So I think the buffer zone will remain. But hey, I'm not a federal district court judge that's going to hear that, so we'll have to wait and see how the judge rules on that. Anyway, the judge is still making some decisions on who can testify, but the prosecution got the green light to call a crash reconstruction expert by the name of Dr. Judson Welker. Now, the defense fought to keep Mr. Welker off the stand, arguing that his methodology was flawed and his expertise too narrow. But the judge disagreed, ruling that Dr. Welcher has the requisite education, training, experience, and familiarity with the subject matter to qualify him as an expert. Now, Mr. Welcher was not part of the first trial, and the Massachusetts State Police Trooper Joseph Paul was the one called to testify about the data from the Miss Reed's Lexus in this particular case. Anyway, he said it showed several rapid accelerations in reverse, consistent with what he called a pedestrian strike. So now both Paul and Welcher were named on the prosecution's witness list for the retrial, but it's unclear if prosecutors are going to call both men to testify. Now, the defense obviously has sought to portray Miss Reed as the victim in this entire thing, saying that O'Keefe was actually killed inside the Albert family home at 34 Fairview Road in Canton, Massachusetts, and then dragged outside and left for dead. Miss Reed has pled not guilty to the charges of second-degree murder, manslaughter, while operating a motor vehicle under the influence and leaving the scene of a crash that resulted in death. Hopefully we'll get a jury. Hopefully we'll get going. 8 weeks, though, ladies and gentlemen. 8 weeks. Thank you, Karen Reed and Alan Jackson, I guess, from the CrimeTalk family here. But it's not an 8 week. Man, you start normal days, 8:30, you go till 5. This is a week and a half trial. Moving along. And I don't think Alan Jackson is going to control the courtroom like he did last time. He owned the place. He acted like he owned the place. He did. Sometimes it's a popularity contest. It shouldn't be a popularity contest between attorneys. But Mr. Brennan, this particular time, he's a lot more experienced. He's going to own that courtroom as well. We'll see who winds up controlling the place. Hopefully, it's the judge. Next, Rex Heuermann and the Gilgo Beach. That's right. Prosecutors played a clip from Jurassic Park at a hearing in the case of the alleged Gilgo Beach serial killer yesterday afternoon in an unusual move to defend their DNA evidence. I say so indeed. Now, the scene from the science flick was used to bolster the argument that the nuclear DNA testing that linked the alleged killer Rex Heuermann to 6 of the 7 slain sex workers was legitimate, as his attorneys pushed to have the evidence tossed out as junk science. So the prosecution expert witness, a guy by the name of Nicole Novoski, the associate director at the Center for Human Identification from the University of North Texas, said the type of science used for DNA analysis by investigators in the Gilgo Beach killings is nothing new and has actually been trusted for decades. Now, during the testimony, prosecutors played a clip for the judge from the popular film franchise showing how scientists extracted dinosaur DNA from a mosquito preserved inside amber and then used it to clone the animal and that have been extinct for some 66 million years. The good doctor said the DNA science referenced in the movie has been around since before it came out in 1993, and it has been verified thousands of times by people in the scientific community. The expert said it's accurate and reliable to use in forensics. Now, defense attorneys asserted that this science is not real, comparing it to magic. The defense attorneys added that the characters in Jurassic Park throughout the movie they had good science, but actually the dinosaur ended up eating everyone, prompted apparently everybody in the courtroom to start chuckling. Now, investigators were forced to use the particular type of nuclear DNA testing rather than the more common used testing because the hair samples of the remains of the women were extremely degraded, in part because of the length of the time between their deaths and when they were finally recovered. Now, Heuermann is charged with killing the women starting back in 1993 and then ditching the women along the Ocean Parkway only for their remains to be found back in 2010 and 2011. It wasn't until July of 2023 that Heuermann, the architect living in Massapequa Park, was arrested for the murders of Amberlynn Costello, Megan Waterman, and Melissa Bartholomew. He has also been charged with killing Maureen Brainerd Barnes in January of 2024, with the 4 women becoming known as the Gilgo Four. Now, Heuermann was later charged with the killing of Valerie Mack, Jessica Taylor, and Sandra Castillo, the earliest victim who was killed back in 1993. Now, police finally announced last month in the investigation into Heuermann's alleged murders had concluded, meaning that they didn't anticipate charging him with any more murders. Anyway, Wednesday was the second day of that hearing on the DNA evidence and Heuermann's case, which began last Friday. He's pled not guilty, entitled to the presumption of innocence. No trial date has yet been set. And next, I'm not sure what to make of this. Cold-blooded killing, stupid kids. It's horrible. Couldn't imagine. Anyway, a Texas high school star athlete was stabbed in the heart and left to die in the arms of his twin brother following a fight over a seat at a track meet. Now, Austin Metcalf was attending a track and field championship between other area schools at a stadium in Frisco, Texas, when he was fatally stabbed. Now, Metcalf was a junior at Frisco's Memorial High School, was in the stands at the stadium when a confrontation broke out between the teen and another teenager by the name of Carmelo Anthony, not the basketball player. Don't think any relation, but Carmelo Anthony. Anyway, Anthony was a senior at Centennial High School and was allegedly told he was sitting in the wrong seat before he drew a knife and then launched his attack, according to Mr. Metcalf's father, Jeff Metcalf. Now, Anthony allegedly stabbed Metcalf in the chest as his victim's brother watched the whole thing take place in horror. Hunter Metcalf called his parents to tell them about the stabbing, and their father rushed to the stands to find Austin on a gurney not breathing. The dad said, "I could see all the blood, and I saw where the wound was, and I was very concerned. So I had to find his brother, and we rushed to the hospital, and we prayed, and it's God's plan. I don't understand it, but they weren't able to save him. This is murder," the dad said. Anyway, the teen was pronounced dead at the local hospital, and despite life-saving measures, which included CPR and administration of blood, he died, according to the Frisco police. Now, Mr. Anthony, also 17, was arrested and charged with first-degree murder. He's being held at the Collin County Jail. No bond has been set. Anyway, the father questioned Anthony's upbringing and parents. Said he forgives his son's alleged killer. "I'm not trying to judge, but what kind of parents did this child have? What was he taught? He brought a knife to a track meet and he murdered my son by stabbing him in the heart? The guy was in the wrong place and they asked him to move. And he bowed up, became angry and aggressive. This is murder," the dad said. The dad continued saying, "You know what? I already forgive this person already. God takes care of things. God is going to take care of me. God is going to take care of my family." I don't know. We'll follow that one. I think that one's going to get interesting. Next on the docket. This guy doesn't like large-scale pharmacies, so he decided killing people. I wonder if he's going to get a fan base like Luigi Mangione. Anyway, the suspected gunman who opened fire inside a California Walgreens on Tuesday night had a grudge against pharmacies, according to the police in their arrest affidavit. And they have video surveillance from inside the Madera, California store where it allegedly shows 30-year-old Narcisco Gallardo Fernandez waving a gun before he opened fire. The shooting left 34-year-old Eric Velasquez, an employee at the store. Now, the Madera police chief, Gianchancho Chiramonte, said that while the motive of the shooting has not yet been declared, Fernandez had made several comments about large pharmacies. Apparently, the statements included that he had very much a lot of anger towards pharmacies in general, not specifically Walgreens. And he added that Fernandez told some victims, "This isn't about you." Fernandez was arrested shortly after the incident, taken into jail and charged with homicide. What the heck, ladies and gentlemen? This man's just simply trying to make a political statement, is he not? Like I said, is he going to get the Luigi Mangione fan club type of people supporting Mr. Fernandez? Somehow I doubt it, indeed. Now, Mr. Fernandez, still young guy. He's not, but he's no Luigi Mangione. Same cause, ladies and gentlemen. Sounds like big pharma, big medicine, big insurance. Where's the hypocrisy of it all? We'll have to wait and see. I'll be counting the Fernandez's GoFundMe pages and supporters. The silence is deafening, isn't it? Next on the docket, past performance is indicative of future results. How often have we said that? Yes, it is. Tell that to the judge all the time. Prosecutors tell that to the judges all the time. Person has failed miserably on probation, in life, etc. Why are we giving him another chance? Anyway, North Carolina man has been charged with murdering his mother and teenage brother just 6 days after being released from prison. Now, Dayron, D-A-R-O-N, common spelling, Jenkins, had walked free on Tuesday of last week after serving more than 5 years for stealing guns and burglarizing vehicles. Now, he moved in with his mother, Dana Jenkins, and she wrote on her Facebook that her baby was home. Lord, I thank you. But Jenkins was swiftly back behind bars, charged with the first-degree murder of his mom and his 15-year-old brother, Darren Cox, who were found dead in their home in Wilson, North Carolina, about 40 miles east of Raleigh. Now, a cousin by the name of Julia Cornegay, who lives next door, stated that the mother and her son were stabbed to death and that their bodies were found after she saw the suspect looking like he just got out of a mental ward. The look on his face told me he'd done something. His hands was cut up, the cousin said, and he had a bandage on his hand. This is all about 3 a.m. on Monday. Now, Jenkins had been showing alarming signs since he was freed from prison. Anyway, the family says, "I'm hurt because I knew he was going to do something," the cousin said. "You can just see he was so fidgety. He was so anxious. He couldn't sit still. He had this sneakiness about him, like a crazy person trying to get ready to do something, like premeditation." Now, Dayron Jenkins was arrested and booked into the Wilson County Jail and being held without bond. He made his initial appearance on Tuesday and will have future appearances. And my guess is they're going to comp him, and it'll probably be a not guilty by reason of insanity type defense. Next on the docket, how about a little legal history? On this day, on April 3rd, 1936, Bruno Hauptmann was executed by electric chair for the kidnapping and murder of Charles and Anne Morrow Lindbergh's baby. That's right, the great Lindbergh baby kidnapping. On April 3rd, 1944, the United States Supreme Court in Smith v. Allwright strikes down the Texas Democratic Party rule limiting primaries to white voters, advancing voting rights and challenging discriminatory legal practices. That's right, that was the Democrat Party saying you could only vote in their primary if you were white. Next, on April 3rd, 1968, Martin Luther King Jr. delivers his final mountaintop speech in Memphis, Tennessee, supporting the sanitation workers' strike. His assassination the next day on April 4th prompts nationwide legal and civil rights responses. And on this day, April 3rd, 1991, and on this day, on April 3rd, 1991, Jeffrey Dahmer is arrested in Milwaukee, Wisconsin, after a victim escapes. His case highlights the legal challenges in proving insanity defenses in serial murder trials. And on this date in 1996, April 3rd, 1996, Theodore Ted Kaczynski, a.k.a. the Unabomber, is arrested by the FBI by agents in Montana, ending an 18-year bombing campaign that killed 3 and injured 23, making a significant victory for federal law enforcement. And on this day, April 3rd, 2000, the United States Supreme Court in the United States versus Microsoft Corporation hears arguments in an antitrust case shaping legal precedent for technology monopolies. Initial arguments began on April 3rd. And finally, our dumb criminal of the day. You can't make this stuff up, ladies and gentlemen. A 50-year-old man has appeared in court after being charged as a chicken thief. Yes, this gives new rise to food crime, I guess, pet crime. I'm not sure. Anyway, a Port Orchard, Washington man allegedly violated an order of protection, shocking, by breaking into his ex-girlfriend's house and then stealing her chicken, according to the police. The call came for help in the early morning hours of March 29th, and a woman who said her former boyfriend invaded her home and snatched her pet chicken named Polly. He allegedly screamed, "I've got Polly," several times before running away, chicken in hand. But after a brief but intense search, police found the man hiding in the woods. Body cam footage shows the man hiding in the bushes as police approached him at gunpoint. He can be heard yelling, "Don't hurt my chicken," as the deputies responded, "I won't hurt your chicken." Anyway, the deputies allowed the man to place Polly safely in a patrol vehicle before taking him into custody and charging him with residential burglary and violation of a protection order. Now, the jail records show that the man had only been released from custody less than 3 hours before the great theft of Polly the chicken. He faces a maximum of 10 years in prison, a $12,000 fine for burglary, and a year of fines totaling $3,100 for violating a court order. Now, the female victim, the owner of Polly the chicken, confirmed that the suspect had just escaped jail and allegedly wanted to take her favorite chicken. Anyway, good to report, Polly the chicken has been returned to her family safe and sound. There you have it, ladies and gentlemen. Who would have thought someone's going to break in and steal Polly the pet chicken? Say that 10 times fast. All right, that's all we have for you today. Hope you enjoyed the show. We'll see you next time. And remember, the Constitution matters.